This is Office Talk with Annette Stepanian. Hey there, I'm back with another Legal Quickie episode. Now, this one is not such a quickie. It's actually kind of the extended version because I have invited my good friend Lonnie GIamela, who is a partner at Fisher Phillips, which is a law firm that specializes in labor and employment issues, to come on the show to help answer some of the common questions I see about hiring. Now, whether you're just starting out or maybe you've gone ahead and actually started hiring folks, I really want you to take a listen to this episode because Lonnie does a really great job of laying down kind of the big subject matter areas that you need to be thinking about when you are ready to hire, or if you've already hired, you want to make sure that you are on point and in compliance. Lonnie gives a lot of great information, and it can be a lot to digest. So what I did is create a cheat sheet for you that you can download, and it basically covers a lot of what he talks about. So the things that you would want to take notes on, I've already done it for you. That cheat sheet is available over in the show notes at AnnetteStepanian.com/podcast/20. Also, make sure to stick around until the end because I have a little something I want to ask you, and I'll talk about it after the show. With that said, let's go to the show. Hey, Lonnie, thank you so much for taking the time to be with us today.
It's a pleasure to be with you, Annette. Thanks so much for having me.
Yeah, hey, it's pleasure is all mine because I know you are such a busy bee over there practicing law. Can you bring our listeners up to date and let us know kind of what you do, what kind of work you do, what kind of law you practice, and all that good stuff?
Yeah, so absolutely. So I work for one of the nation's oldest labor and employment boutique law firms, Fisher Phillips. We have 33 offices across the country, 5 of which are here in California, between Sacramento, San Francisco, San Diego, Orange County, and where I am right now in downtown Los Angeles. And what we do is we represent employers of all sizes, startup business all the way up to a Fortune 100 company, in everything that's associated with the employment relationship, including independent contractor, immigration, benefits compliance, and the like. So regardless of whether you have a quick question about a termination or preparation of a handbook or a service contract, perhaps with an independent contractor that you want to make sure has all the belt and suspenders, all the way up into litigation or audits, our firm is here to help you out with that.
That is perfect, and I can't wait to talk to you because I know it's going to be super valuable for our listeners because a lot of them are entrepreneurs and they're either starting out, maybe they're in their first year of business or so to maybe a few years out, and hiring inevitably comes up and it's a question that they all have. What do we do? And there's so many laws and rules and you know the deal, right? So
Absolutely.
So can we just start kind of let's do, the sound of music. Let's start at the very beginning. And when somebody is looking to hire, so I know one of the first questions that they need to think about is, how do I classify this worker? Are they an independent contractor or an employee? Can you kind of run through some of the questions that they need to be asking themselves to determine how they're going to make that classification?
Absolutely. So here is the number one rule for your listeners. Under California law and even across the country, if 2 people, although we say it's a contract, this person agreed to it, they want to be a contractor, what 2 parties agree to is not necessarily what is going to be lawful or unlawful. Even though 2 people may contract to be an independent contractor, that only satisfies the first part of the process. You still have to satisfy all the requirements under state or federal law regarding satisfaction of an independent contractor. Likewise, you can't go to someone who you may want to hire and try to agree to change the laws, whether it be state or federal, regarding wages, wage payment, overtime, and the like, because again, those all fit into criteria. You can't just agree to be unbound by the laws. Mm-hmm. But with respect to independent contractor, here's what you're looking at, okay? If the person who is providing you the service or the labor needs to be something that is not central to your operations. So if you're a caterer and you need an assistant to help you plan an event, that is not an independent contractor. Mm-hmm. Likewise, the labor that supplies for an event that you put on is not. The test will require you to show that the service that somebody is providing to you is separate and distinct from the central operations of your business. So if you are a small business and you hire a web design company or a social networking or a social networking marketing or a web-based marketing company, a lawyer, an accountant, a janitor, a plumber, all those are not central per se to your business and are specialized such that you can bring them in order to do that. The trick is to make sure that if you are retaining an individual services you're not paying as a business, but you're paying as an individual, that's an automatic red flag. If that's the case, you're going to want to make sure and guarantee that service provider to your business is providing services to multiple other institutions, businesses, and entities and can prove that to you.
Okay.
Because if they're only giving, let's just say, if you're an entrepreneur and you're hiring someone to be an accountant or to provide bookkeeping services to you, but that bookkeeper doesn't do anything for anyone but for you, that's a part-time employee. Mm-hmm. So that's sort of the first hurdle that people come into. Is the first test is that you have to have, it's not typically 9 parts under a state law, 20 parts under federal law, but the first concrete rule is that you have to have a written agreement. Mm-hmm. The second one is that you have to show that they are not doing something central to your operations. And the third is that they're doing it for other people at the same time.
Okay. That makes sense. So like, for instance, I work with a lot of event planners who want to hire day of assistants. So these are people who come in on the day of the wedding and they just help them out just for their day. And it's very common in the industry to classify these people as independent contractors. However, it sounds like unless that assistant is in the business, let's say, of running, being an assistant to a lot of other people, it's probably more like this person's going to be a part-time employee.
Yeah, although it's not an ideal way. Yeah. The way that event planners, if that's the case, and very likely these people would be employees, but you would want, for example, if I'm the event planner, Annette, and I need you to help me out that day, I would love it if there was a Events by Annette business that would invoice me and I would pay you, and that you could show that you're trying to do this with other people as well too, such that we're collaborating and putting on the event together as two businesses, as opposed to me hiring you to do it. But what comes into play, and people say, well, we'll just do that with everything we do. The problem is that once you get past these first 3 hurdles, you get into the next set of hurdles on the test, would deal with what is referred to as behavior and financial control, meaning, do you as the business owner control the time, place, and manner in which the services are rendered, or does the service provider? So if I am a small business and I hire a web design team, they're going to tell me we're going to have a web project back to you in 3 weeks. We're going to control how it is, and this is how much it's going to cost. I say, great. But if I hire someone to say, be at my office at 9, you're going to leave at 5, this is what you're going to do, and I'm going to supervise you all day, then you're going towards an employee. Mm-hmm.
Yeah, and so it's like there is no one factor. It's just this balancing. And I mean, from what I understand, it's whether or not you actually control somebody's behavior is irrelevant. It's the fact that you have the ability to control their behavior. Is that correct?
Correct. So what you're going to be wanting to do, the IRS website, if you type in, and don't worry, if you go to the IRS website, they're not tracking you. If you can go to irs.gov and type in independent contractor test, they'll provide it to you. If individuals want to look at it from a state law perspective, for example, here in California, the test is called the Borrello test. And it's based on a case called Borrello, where the court goes over a bunch of tests to determine whether or not someone is an independent contractor. And why is this important? One of your listeners may be asking, well, come on, I pay the person, a couple $100. What's the big deal? Well, if you have an independent contractor who files for unemployment insurance and they use your business name and that contractor doesn't pop up on your quarterly tax returns or in your account for the quarterly payroll tax that's been paid, it triggers an automatic audit of your company to determine whether or not you're paying people properly. And for a small business, it's a huge nuisance where you have to go through this process and the like, and perhaps pay some penalties in addition to the personal income tax. So you want to be very cautious about that.
Yeah, that's a good point. That was my next question, is like, why should I even care? And so there are some real ramifications there. And so do you see that happening a lot in your line of work? Do you see that this...
Yeah, so the way I would say, I'll concede that I don't see it with smaller businesses with payroll tax audits, but let me give you an example.
Okay.
A net catering company or a net small business, whatever it is, you're up in the Bay Area, you're a startup, or you have some business idea, and let's say you're just a person, you're a 2 to 5 employee or even a 50 employee shop. If you hire someone to come in for a couple days to provide services as a contractor, they are deemed to be an employee and they dispute it, and you get in some dispute as to how much that person is owed, they can file a labor board claim. Now, the amount of wages that they would be seeking is very small, but the penalties are equivalent to 240 times or 30 days of an individual's daily rate of pay, or 240 times the hourly rate of pay.
Oh my God.
So that's $4,000 or $5,000 at least, even at $12 or $15 an hour. So a listener of yours needs to be concerned that this is where we see it a lot, where somebody goes in, gets in a dispute, files a claim for $7,000 or $8,000. The entrepreneur is unfamiliar with the process but needs representation. The representation is almost as expensive as the claim itself, so they're stuck between a rock and a hard place in that regard.
Mm-hmm. So what do you recommend if they are, God forbid, if they find themselves in that situation? What do they do? Do they just, and I know that depends on the case and stuff, but should they come and seek out a lawyer like you who has experience in this, or trying to resolve it themselves? Or are there any other resources that they could seek out?
Yeah, absolutely. So the California Chamber of Commerce provides some help to small businesses. But yes, absolutely. My recommendation for any of your listeners is that if you ever get something with respect to payroll tax from the Employment Development Department or the IRS, if you get a labor board claim from the Division of Labor Standards Enforcement, which is our state labor board, or in the state in which your business operates, whether it be anywhere from California all the way to Massachusetts, and that they should consult with legal counsel. And, we have to keep in mind, too, that I would recommend that your listeners be very mindful, particularly those in California, that there are probably 7 or 8 cities now that have separate minimum wage ordinances, paid sick leave ordinances, and service fee ordinances, like the city of Santa Monica, for example. Mm-hmm. On how service fees need to be distributed. But if you're in the Bay Area, and let's just say your business is located in Palo Alto, but you have an event in Emeryville, Oakland, or San Jose, the event that you're putting on, you're going to have to pay employees a higher minimum wage than you would if that event was in Fresno, Palo Alto, or down here in, let's just say, Burbank, California. Mm-hmm. So you have to do the research. If you're unfamiliar with cities, and particularly if you're in the Bay Area, San Jose, San Francisco, Oakland, Berkeley, and Emeryville all have unique rules in their cities for labor that's performed within their city's jurisdictions. And
as if it wasn't complicated enough.
Yeah, so now we have local, city, and state, and minimum wages over the next 5 years going up in each various jurisdictions.
Okay, so actually you bring up a really good point, because a lot of my listeners might be doing work in one state, and then they might hire assistants, or a lot of people work virtually. So they might be living and operating their business in California, but they're hiring somebody in New York to do work for them. And let's assume they're employees, not independent contractors. What do they need to be concerned about there if they're working with somebody who lives outside of the state in which they run their business?
So depending on the state and the jurisdiction, if you are hiring an employee in another state, you will arguably need to register as a small business employer in those states in order for you to pay payroll tax. The big issue typically is dependent upon the size of the number of employees you have in the state, whether the state has state income tax or any type of state tax that's assessed to employees, and likewise whether there are workers' compensation requirements in those states. So it's frequently one of the things that go unnoticed for a small business when they hire someone is the cost of having to register. And this typically prompts a small business to say, you know what, I'm just going to designate them as a contractor, particularly if it's some type of virtual base, because it's typically computer based and everyone is invoicing one another, which is fine, I guess, in concept, but you still, if that person is misclassified, it could still subject you to unnecessary penalties.
Okay. So there, it's if you're hiring an employee who's outside the state or even the city in which you do your business, you have to make sure that you're in compliance with the rules that they're in their jurisdiction or where that employee is located.
Yeah. So
okay.
When an employer starts business in a new state, I would recommend that they seek legal counsel at least for an hour or two, because I do think it's worth it to make sure that the classification is correct and new laws and obligations for an employer are done. So just case in point, in California, we have a provision here, two laws, that one at the time of hire, there are a series of forms that employers are required to provide to employees, one of which is the Wage Theft Protection Act notice. Mm-hmm. And if that notice is not provided, there is a penalty per employee. Likewise, we have pay stub requirements. And California is a state where now we have 10 things that must be put on a pay stub: the name and address of the employer, the gross wages, the deductions, the net wages, things of that nature, the paid sick leave if they're entitled to that on it. And if not, it's $50 for the first violation for each employee and $100 for each additional violation. And it goes so much that, for example, if your company, Annette, was Catering by Annette Inc., and the name that you put on your business paycheck was Catering by Annette, mm-hmm. and you didn't Inc., it's a violation.
Of course it is.
Of course. So your listeners need to be careful when they're setting up shop, particularly in another state, or they're starting to hire. Typically, when you get to the first employee, 5 employees, 10 employees, 25, and then 50, all new, and this is anywhere in the country. So it could be 1 employee here and 4 in different states, but 1, 5, 10, 25, 50, and 100, as far as an employee population, those trigger all new requirements depending on the state. So you have to be careful when you get to those to make sure that you're providing the proper notices to employee, maintaining proper policies in the handbook, and as well as that, making sure that you're paying employees in accordance with the proper laws.
Okay, so this is super, super helpful. And because I find that a lot of the folks that I work with or the listeners, they really want to do the right thing. You know, they take their business seriously. They want to, they don't want to break any laws. But as you've just demonstrated, there's so many rules and it's so complicated. And as a business owner, you're busy running your business. So you mentioned that, let's say somebody has determined I'm hiring an employee, they're, local or whatever, wherever they're located. What's that first thing they do? They hopefully contact a lawyer who has experience with labor and employment law to bring them up to speed. But what mm-hmm. are some of the buckets or kind of like the high level bullet points of things that they need to be thinking about? So you said wage and hours. So that's, how these people get paid. Like, can you kind of go over okay, these are the 5 topic areas that I need to be aware of when I do go talk to my lawyer. I want to make sure I cover these points.
Yeah, absolutely. So the first one that you're going to want to talk about is the wage hour standpoint. And that could range anything from what are my obligations of paying the employee? Am I going to owe overtime, meal and rest period obligations? And how, for example, am I going to document this employee's time, especially since I presume, particularly for smaller businesses, they keep time not electronically via a timekeeping system, but perhaps via email or a handwritten timesheet, something of that nature. Mm-hmm. The second thing that you want to go through is making sure that you are documenting with this employee, if they are, that they're going to be employed on an at-will basis. So there's no dispute that this person had a contract for a specific duration or a specific time. If that's what you want to offer somebody, and you've never prepared an agreement like this before, you should certainly consult with counsel, because termination obligations in these contract cases are huge. Third, you're going to want to talk about independent contractor obligations. If you're going to go down that route, making sure that you properly designate. Because, for example, if it's catering by a net and you retain me as an independent contractor, and I go out and I spend $2,000 on equipment and goods to do a job just for you, and I'm later found to be an employee, I can seek reimbursement from those costs for you, because you misclassified me as an independent contractor. So designating independent contractor after you look at the at-will, the wage hour. The fourth thing is that you want to make sure that you have all the required new hire documents if this is an employee being provided to an employee. And these range from everything from pamphlets that need to be handed out to an employee all the way up to policies, or in which I would recommend a big one for your client or your listeners to invest in, which is confidentiality agreements to preserve the business interest and the trade secrets. And those are all state by state specific. So for example, if you utilized an Arizona compliant agreement in California, it would likely be non-compliant in California, as it would be in Illinois, for example, or New York, for example.
Why is that?
Each state recognizes in various degrees limits on your ability to place restrictions on an ability to compete or recruit. So for example, in a state like Arizona, you can have a non-compete agreement so long as there are proper geographical restrictions and subject matter jurisdictions. In California, you cannot have a blanket non-compete in any way, shape, or form, regardless of geography or business venture. You can have a non-compete using confidential information, but you can't put somebody on ice for a year, let's say.
So actually, can we take a step back? Can you explain to our listeners the difference between non-compete, non-solicitation, confidentiality, kind of, because I think sometimes those terms get used interchangeably, but they actually mean different things, right?
Yeah. So exactly. So a confidentiality agreement is an agreement between you, and it can be either with an employee or an independent contractor, where they are agreeing not to misappropriate or misuse your confidential information both during and after employment is over. And that's sort of one bucket. In these agreements, you'll typically say a confidentiality agreement or an NDA. That's that first bucket. The second bucket, which either could be a separate agreement or a paragraph in an NDA, is a non-compete, where an individual, after they cease providing services, is agreeing not to compete with you post-termination.
So they can't go out and, let's say I hired somebody for my catering company, they can't go out and start their own catering company that directly competes with me. That's what, in theory, a non-compete covers.
Correct. So in California, that would be improper, but you could make that employee agree not to use any of your confidential information, such as your branding, your customer lists, whatever. And if they did, that would violate your rights under the law. You just can't have a blanket agreement. In other states you can, just not in California. And finally, there's a third bucket called a non-recruiting agreement, where you can require an employee or a contractor post-termination not to recruit your employees. Now, that's different than hiring them. If an employee wants to voluntarily leave your company and go work for a competitor, you can't stop anybody. But you can allow and prohibit employees from recruiting your employees once they leave your employ.
And so you said the non-compete and the non-solicitation are the ones that are very state specific in terms of what is valid and what's not. But the confidentiality is you can still have a confidentiality agreement, correct?
Yeah.
Okay.
Correct. So if your listeners have one right now, take a look at the agreement that they're utilizing if it's in California, hypothetically.
Yeah.
Okay. And if you look through that agreement and there's a non-recruitment, no hire provision, and it says that they cannot hire people after they're employed, that's a red flag. If they have in there, if anywhere in there is about not competing within a geographical location or in a certain industry, that's a red flag, because that agreement was probably done, or I should say possibly done, for operations in another state and given to them. So it is a state-by-state required analysis.
Okay, I have kind of a nerdy legal question. So if they find that they have a term in there that is, let's say, not in compliance with their state's laws, does that make that agreement invalid, or?
It doesn't.
Okay.
It depends on the state, but in California, it would.
Okay.
There's a potential at least for it. So that's why if you have a non-compete in a confidentiality NDA agreement, you could be blowing up your entire agreement by use of an improper provision. That's why it's so important to look at it to make sure that you're doing it properly.
Okay, cool. This is such good stuff, Lonnie. I'm getting all nerdy here. I'm getting so excited here. Okay, cool. So while we're on the subject of contracts, so what about the actual employee-employer contract? So I've decided I'm going to be hiring you to come work for my catering company. What does that have to govern? Are there any things that we have to make sure we address in that contract?
Yeah, absolutely. So when you offer an employee, either by way of an offer letter or a contract, you want to make sure you're going to cover probably three main points. The first is, are they going to be at will, or are they going to be terminable only for cause? And if so, you have to define cause. And also, if you terminate them without cause, what is the employee entitled to? The second thing you're going to want to discuss with them is sort of, as I like to call it, compensation data, which is when they start, what their hours are going to be, how much they're going to be paid, who they're going to report to, things of that nature. And lastly, in an offer letter or contract, you're going to want to discuss at least the obligations that the employee will have to you, either by way of confidentiality agreement and the like. Now, if you are perhaps a startup or a small or a medium size or even a large business that is going to do a background check, a drug test, or a criminal background check of some type, all of which there are restrictions on depending on the state and the city, you need to notify them of that in the offer letter and then provide them the authorization forms in which to do that. And then once that's done, you can get to an employment agreement. For at-will employees, your employment agreement will probably be just your handbook with some at-will language on it, or some, terms of art that contains things like policies against harassment, and what the fringe benefits will be. So as vacation time, sick time, things of that nature.
Okay. So that's the stuff that goes usually in a handbook or like a manual or some sort of policies and procedures that you give them with the contract.
Correct.
Okay. And so if I'm a small business owner, I'm one person, I'm hiring another person to come in and maybe help me with my catering business. Do I really need all of this stuff? Do I really need to make this investment?
Run that by me one more time.
I said, if I'm one person, because I could see a lot of people thinking, if I'm one person, let's say I'm just hiring one employee, do I really need to make this investment? And I don't have a sexual harassment policy. What do as practically speaking, I could see a lot of people thinking, well, do I really need it? Can I just get away with my first one or two employees without this stuff?
Yes. Yeah. So there are, I would say that you probably don't need an employee handbook.
Okay.
You have to make sure, though, that all employers are required to put postings in the workplace. But for those smaller employers, you're going to be wanting to look at perhaps a 1 to 2 page offer letter / employment agreement that outlines all the terms and conditions, because that's where the dispute is going to be for the small business. You didn't pay me what we agreed to. You offered me benefits and I'm not getting them. My vacation is different than what you told me. So you want to make sure that everything is in writing, including but not limited to the at-will nature of their employment.
Okay. And speaking of benefits, are there any requirements that they have to give them? I mean, wage and hour is a different topic. That's about how many hours they can work and overtime and all that stuff. But am I required to give an employee 2 weeks of vacation or holidays or pay for their insurance? Like, can you talk about that? Because I know there's been a lot of changes in that realm as well.
There's 3 buckets. The first bucket is vacation time, holiday pay, life insurance, long-term disability, short-term disability. All of those are optional. You're under no obligation to provide it to an employee. Okay? The second one is paid sick leave. Depending on the size of your business in the city you're located in, you would have obligations for between 24 hours, perhaps up to 72 hours, depending on where you're located, to provide employees each year, depending on the number of hours that they work. Certain cities have it, in addition to the state of California has it as well too. So that more often than not, most employers will be covered there, but it typically starts after an employee has worked 30 hours for you. The sick leave is not payable at termination, but you have to accrue it properly. So if someone's working you for a day or two, it's not going to happen. But if they're working with you for more than a week or so, that's when it might start coming up. In addition to that as well, paid sick time is typically not usable until 90 days of employment. So it's really moot if you're hiring essentially temp-based or one-time off employees. The benefits is a whole different Pandora's box from a medical standpoint. Depending on the size of your business and depending on your jurisdiction, you have various healthcare obligations to your employees. So even small businesses, for example, in the Bay Area, depending on the city, who they're contracting with, their industry, and who they're doing business with, could have, for example, obligations under the healthcare ordinance in the city of San Francisco to pay employees for the work that they do there. Now, it's only relevant to a small percentage, but I bring it out there for your listeners so that they know that there are obligations. Now, from a federal level, everything is really up in the air with the new administration and what they're going to do. And it's not so much as replacing it as if what provisions they're going to repeal, if any, of the Affordable Care Act. And I would, advise your listeners to really pay attention over the first 90 days of the new year to see how that's going to affect them as small businesses, if at all, and whether new obligations are going to be placed on them or obligations are going to be taken away from them.
And you bring up a good point, because the law is always changing, and therefore our obligations and responsibilities are always changing. And so I always recommend people, for instance, to revisit their contracts every year. What do you recommend so that people keep up to date on any obligations that they might have? Do they check in with a lawyer every quarter, or how should they start planning this process out as they intend to hire people and grow?
So this is probably an opportune time for your listeners, because there are numerous law firms, including mine, who during the months of December and January put on legislative updates for the general public to come listen to the new laws. And you could, if you go to, and just to be neutral and recognizing the great work that colleagues at other firms do, you can go to elinfonet.com. It stands for the Employment Law Information Network. And that's where all the law firms sort of dump all their events, and in addition to that, all their content based on the state for people to read. So it's a good initial resource. Chambers of Commerce put on legislative updates, and in addition to that, human resources organizations across the country. Here in California, we have 2, PIRA and SHRM, that are human resources groups. And SHRM is SHRM for those who are looking online for an event. And PIRA is PIHRA.
Awesome. We'll put all of these links in the show notes that go along with the podcast, so people can go and click them. But these are amazing resources, so thank you for sharing them. Sorry, I didn't mean to interrupt, but
no problem. So it'd be good for people to take a look at in that regard and sort of get an update. I mean, we're going to have, one thing, for example, that's going to affect a business. Let's say you're a business that has your own restroom. in it. You're a small business and you're leasing space in some office building, but you have a restroom in your bathroom that's available to the public. You have to switch the signage in response to new gender identity laws in the state effective March of next year. We have new state minimum wage laws. We have new Equal Pay Act laws that people have to be mindful of. And we have, in addition to that, changes perhaps to the minimum that an employee needs to be paid in order to be exempt under the law. So all of those are critical things that people should explore, going to a 1 or a 2 hour seminar or finding an employment lawyer and asking them to do business. And the one thing that I would always caution and recommend is when you're speaking to someone to help you out, you want to make sure that they are familiar with your industry or have experience guiding, providing advice to, or representing clients in your industry. Because, for example, someone, Annette, who is a small business web retailer that might be listening to you is going to have much different concerns, perhaps on confidentiality specifically, than an event planner or an event provider who's going to be worried, for example, more about tip pooling obligations or split shifts, things of that nature from a wage hour context, since their labor will be much more perhaps manual and hourly than a smaller business that may be office-based and have only salary-based employees.
Mm-hmm. And so what are some questions that they can ask in determining if that person has that, requisite experience?
It's sort of a simple question when you ask is saying, hey, this is my industry. I'm having a bunch of questions of how to expand or compliance. Do you have experience representing, similar businesses in my industry where you understand the things that I'm going through?
Yep. Yeah, I always say, finding a lawyer is a lot like going to a doctor. Like if you have a heart problem, like you're going to go to a cardiologist, you're not going to go to a foot doctor or a pediatrician in theory, right? Even though that doctor has studied the body, understands medicine, they have their area of expertise. And so it's the same thing with a lawyer. If you are getting a divorce, you're going to go to probably a family lawyer or a divorce attorney. You're probably not going to go to, a securities attorney or somebody who does like mergers and acquisitions. So yeah, you want to take that time, and it's always good to kind of build that team before you need it and start building those relationships and contacts so that if and when you're ready, you have somebody that you could just pick up the phone and call them and make, time to speak with them.
Exactly.
Cool. So Lonnie, any other kind of last tips or things, that maybe you've seen with either your clients or folks that you speak to, just about kind of best practices as people move forward?
The smaller your business, the more it's worth just making sure to consult once or twice about minimum wage laws and overtime laws to make sure that you're not stuck with an unnecessary labor board complaint, particularly if you have hourly employees or you have contracted individuals that you're paying on an hourly basis. Those are big things that we want to avoid and help small businesses avoid litigation or labor board complaints that'll sink their business. But it's always worth, just like you were raising, Annette, the doctor's hypothetical earlier, an ounce of prevention is worth a day of surgery, as I like to call it. So, an hour for a couple $100, just with a meeting with an attorney, just going over questions is much worth screwing up and then having $5,000 or $6,000 of damages that you have to owe an employee or a misclassified individual at a labor board complaint.
Yeah, that's something that I keep telling people, but it's sometimes you just got to feel that burn before feel that sting before you learn your lesson. But it's so true. If you can do it kind of from the beginning, understand your obligations, it's like why you wear a seatbelt, right? You hope you're never going to get into an accident, but when, God forbid, if you do, you're really happy you have that seatbelt strapped in and you're in place. So Lonnie, this has been amazing. I am so appreciative that you have taken the time. I know you're super busy, running your own practice and dealing with your own clients, and this information I know is going to be so helpful to the listeners. And I'm going to link up all of the great resources that you provided also, as well as where they can reach out to you if they have questions and want to kind of take this conversation further. So thank you.
Awesome. And as I always tell people, the best thing that you can ever happen is not to have to talk to a lawyer. So if I don't hear from anyone, I hope that means that everyone's still in compliance and doing well. So all the best.
So there you go. If you'd like to learn more about Lonnie, as well as check out the resources that he mentioned during the show, head on over to the show notes available at AnnetteStepanian.com/podcast/20. There you'll also find that cheat sheet that I mentioned earlier, where I've taken notes about what Lonnie said so you can have that to use for your future reference. Also, remember I had something I wanted to ask you? Well, one of my goals this year is to get to know you better so that I can make sure to create the kind of content, such as these podcast episodes, webinars, programs, whatever it is, that can really help you and your unique business. But to do that, I first need a little feedback. So if you would be kind enough to take my quick How Can I Serve You Better survey, it's available over at my website at AnnetteStepanian.com/tellme. So that's all one word, TELLME, or you can find the survey in the show notes. I would truly, truly appreciate it. And to thank you for your time and your honest feedback, at the end of the survey, you'll get a limited time discount code for 20% off all contract templates on the site. So that offer for the discount code is only available through January 20th of 2017. If you've been eyeing one of my contract templates, this is a great opportunity not only to help a sister out, but to also save some money on those contract templates. To wrap it up, regardless of where you are on your hiring journey, there is going to come a time when you are going to need help. You're going to hire whether it's a virtual assistant or a full-time employee or an independent contractor. Whatever it is, you're going to need to understand the basics of what it means when you, as a business owner, start hiring people. So the sooner that you can learn about the different responsibilities that you have as an employer to these different types of workers, then you are that much more ahead of the game. I hope that this extended legal quickie has been helpful in getting you there. Thank you so much for being here, and I can't wait to talk to you later.